step, if the commission has not said that something is extraordinary and compelling, so in other words, it's been silent on it, it said other things are extraordinary and compelling, but has not said this is, would it be permissible for a district judge then to say that such a reduction is consistent with the applicable policy statements? In other words, how do you read commission's silence on the particular issue?
We read it as preclusive, Your Honor. We don't think that this could be brought today under the commission's current policy statement. I mean, maybe there would be some debate about that, but I don't think there would be much. I think it's always been understood that the commission's
and that's kind of the end of it then for this case, isn't it, under your view? I mean, that's one way, that's the end of it, which is the commission has not issued a policy statement that authorizes or that suggests something like this is extraordinary and compelling, and that's an independent requirement of the statute, and that's the end of it? Is that one of your arguments?
Well, that's not going to be the end of this case because it arose when the policy statement wasn't in effect, so we wouldn't apply the policy statement to him unless
there's never been a policy statement that authorizes this.
That's correct, Your Honor, but I don't think the court can rest on that as a potential limitation to the loophole because, as we'll get into more in the next case, there's always the possibility that the Sentencing Commission could do that. We could have another period where for some reason there isn't a policy statement and then it becomes a free-for-all. There also is, and we think it's a quite limited one, there is a subsection B5 to the current policy statement, 1B113, which is an other reason statement, and we could imagine prisoners correctly or not trying to, we think incorrectly, but I'm sure they would assert correctly, trying to jam in what are their recycled 2255 claims under that. And the real problem with that, and this gets to something you were discussing with Petitioner's Counsel, Justice Kagan, is what we're doing is we're taking the limitations that 2255 imposes and we're replacing them with Section 3582C1A1 considerations to make some kind of Frankenstein monster that I don't think is what Congress intended. For instance, take your example of someone who misses the filing deadline by 3 days or 3 weeks or even 3 years. And the person says, well, okay, there is a doctrine that would handle that under 2255. It's equitable tolling. Now, I can't show you any circumstances that are sufficient for equitable tolling. But what I can show you is that I've really rehabilitated in prison. So that's the reason to let me out. That is nothing but a complete end around to a Section 2255 claim. You are using the 2255 claim there as essentially the sole reason for reducing the sentence, except for rehabilitation, which is the one thing we know Congress did not want to be the reason that people are granted early release.
But I guess